please.
Jono Naylor.
I move that the question be now put.
Mr. Chairman.
I'm going to hear the Honourable David Cunliffe.
Mr. Chairman, thank you. I wish to make a reasonably technical contribution to this discussion, and specifically around Clause 5 of Part 1, which I don't believe has been addressed yet in the discussion. There are many clauses that we have not yet touched upon in this Part 1 debate. Sir, before I do, may I make a brief comment in respect of the previous exchange, and I'm sure you will reflect, sir, on the ability of members to cause offence or otherwise in stating their understanding of the members' comments about them.
This is out of order. Just continue with the debate.
Mr. Chairman.
Honourable David.
Mr. Chairman, Clause 5 requires 2 new subsections be added. The first is that an order in council may incorporate a map, plan or document prepared or issued by any person or body. Now that's a very significant, although ostensibly technical, amendment. Let me comment in 2 parts. The first is to replace what would have been a requirement for technical and specific language with any range of map, plan or document. It's therefore possible, indeed probably intended, that move would make it easier for an SHA to cover a broader area, a broader range, a larger quantum of development. In considering that, sir, the House has to take account of the rights that attach to normal consenting processes that are necessarily abrogated by this extension of the SHA process. And those are serious issues, sir. Now, the next part of that clause, I think, adds to that serious question. And that's because this map or plan may be issued by any person or body, not a territorial authority, not a regional authority, not the Auckland Council, but perhaps by a developer, perhaps by an interest group, perhaps by the Tree Council, perhaps by Greenpeace, perhaps by the Property Council. The point, sir, is that members can readily see that the uncertainty which this creates is both unnecessary and significant, given the fact that the rest of the clause seeks to extend and abrogate rights which are extant in the law as it stands. And it's unclear, and I invite the Minister to comment because we're fortunate to have the responsible Minister in the chair, what is the reasoning behind this specific clause? Is it, perchance, the result of developer pressure for an even faster and more speedy process? Is it to abrogate the democratic processes of, perchance, the Auckland Council or other territorial authorities? Or is there a more sanguine explanation which is not apparent to members of this House? I'm sure the Minister will want to comment on that. Mr. Chair, may I reflect on the fact that there is an interesting contradistinction between this clause which the member has added, which allows a policy change to be done by a broad area, a large group of housing opportunities, and contrast it to the approach that the same government, I think possibly the same minister, took in regard to the tree trimming regulations in Auckland, where they removed just such an ability and required people who wanted to protect something, in this case special trees, to do it by the individual tree, which had to be specified by a long and bureaucratic process of the council. In fact, more trees probably died on the paperwork required by that highly specific amendment, and in this bill, the same minister is doing the exact opposite. So, to protect something, you have to be specific to the individual tree, or, thanks to Mr. Goff's pressure, perhaps a very small group of trees. But if you want to develop something, you can do it by anybody providing a map. Imagine Captain Cook providing a map. He could do the whole country in one go. I mean, the point is the clause, sir, that might sound ridiculous, the clause does not self-limit. The clause, and Mr. Jono would be best to constrain his interventions to something that had substance. He's made his speech. Mr Chairman, thank you for the opportunity to ask the Minister to comment on this, and I hope he will.
I'm going to call Phil Twyford.
Mr Chairman,